So, welcome to today's dialogue, which is titled Bridging the Gap Between Foreign Investor Rights and Obligations Towards Reimagining International Law on Foreign Investment. My name is Tracy Robinson. I teach law at the University of the West Indies on its Mona campus in Jamaica. We are one of the co sponsors of this particular dialogue. I'm currently Deputy Dean in the Faculty of Law. With responsibility for graduate studies and research. This dialogue is also co-sponsored by University of Valparaiso, Chile, and the International Law Association Caribbean branch, which is led by Chantal Onanawu, who is one of the discussants today. We particularly welcome you from all over Latin America and the Caribbean and beyond. Nicholas Perrone, Professor of Economic Law at the University of Valparaiso, and I, along with ILA Caribbean, organized today's dialogue. And our goal is really to encourage more global South conversations between legal scholars who are in Latin America and the Caribbean and working on Latin America and the Caribbean, and particularly on the issues which are the most critical to us related to our development, responding to our similar histories or present preoccupations and or predicaments. Without question, today's conversation on the gap between foreign investor rights and obligations is a critical one for our hemisphere. Nicholas will lead the discussion and talk a little bit about his forthcoming article that bears the same title as the discussion today. His article will soon be published by the Business Human Rights Law Journal. And his main research interests are in international economic law, particularly international investment law and policy. Among many other things, he previously taught at Durham University, many connections between the participants here today, including Durham, the Institute for Global Law and Policy at Harvard Law School, Universidad Externado de Colombia, and he has been a visiting professor in many other places, including in China. Fabia Fernandez Carvalho will follow with her comments, and she has a PhD in international law from University of Sao Paulo in Brazil, and she's recently served in a postdoctoral role with the laureate program in international law at Melbourne Law School in Australia. Her research and teaching interests are focused on the theory and history of international law, regionalism and Latin America, Brazilian and third world approaches to international law and international human rights law. Kevin Davis follows, and Kevin is the Bella Family Professor of Business Law at NYU Law School, and his research and teaching generally concern the relationship between law and economic development, with particular focus on anti-corruption law, commercial law, and measurement of the performance of legal systems. Kevin works extensively in Latin America and also in the Caribbean, and has had visiting appointments at Cambridge University, FGV School of Law in Brazil, the University of Southern California, University of the West Indies, University of Toronto, and lectured at many other institutions. Chantal follows Kevin with her comments, and she is a trade policy and legal specialist with the Caribbean Community CARICOM Secretariat based in Barbados. She's also the president of the International Law Association Caribbean branch, which co-sponsors today's dialogue, and she's a graduate of the University of the West Indies, teacher at the University of the West Indies, holds a DPhil in law from the University of Oxford, Rhodes Scholar. After Chantal, we'll hear the recorded remarks of Humberto Canto Rivera. And he's a professor at the School of Law and Social Sciences of the University of Monterrey, Mexico, and the director of its Human Rights and Business Institute. He holds an LLD from Université Pantheon Assas. He has published extensively on business and human rights and is the founding director of the Latin American Academy on Human Rights and Business. He's a vice president of the Global Business and Human Rights Scholars Association. He's also a member of the steering committee for the Teaching Business and Human Rights Forum. My colleague, Jason Haynes, follows Humberto. And Jason is the Deputy Dean Graduate Studies and Research at my sister campus, the University of the West Indies, Cayville, Barbados. Jason's research interests are diverse, include sports, entertainment and IP law, international investment law, international and comparative law, administrative and human rights law, arbitration and mediation. He was recently named the laureate of the UNESCO Juan Bosch Prize for the promotion of social science research in Latin America and the Caribbean for his work on anti-trafficking law and practice. He's taught at Durham Law School, graduate there too, and also at the University of the West Indies, Mona campus, where I am, and Arden University, UK, and also worked with the Eastern Caribbean Supreme Court. Welcome to you all. It's a pleasure to have you here. Over to you, Nicholas.
Thank you very much, Tracy, for the presentation and also for agreeing to co-organize together with Chantal this event. I'm thrilled that we have the opportunity here to have a conversation with global law, global South scholars about international economic law, international investment law, business and human rights. I'm particularly pleased that we have the possibility to have this exchange between Latin American, Caribbean scholars. I mean, many things bring us together: geography, the international division of labor, similar problems towards development. But at the same time, unfortunately, I think we have missed opportunities to have conversations. There are other things that take us apart, like language and legal education. But I think this is great. It's a great initiative, and I'm very happy to be here today. So in a way, my paper is just an excuse to kick off this conversation. Hopefully, there will be more chances to talk. I will be laying down some points for discussions that others may pick up later on in their own interventions. The paper I'll be talking about today is a spin-off of my book, Investment Treaties and the Legal Imagination. The book is essentially about investor rights, investment treaties, and investor-state dispute settlement, or ISDS, or investment arbitration. Investor obligations, the field of business and human rights plays a secondary role in the book. The paper I'm talking about today is all about obligations, but if the argument is similar, it's the other side of the argument if you want to. So the argument of the book is that financiers and corporate lawyers united to bring certainty to the international law for an investment at times of quite intense indeterminacy. I'm talking about the 1950s here, late 1950s. So they put forward ambitious ideas, financiers and corporate lawyers, such as investor-state dispute settlement, which allows foreign investors to sue states without exhausting local remedies before arbitral tribunals. So these are private actors suing states without exhausting local remedies. And they did this through an intense practice and continuous efforts that managed to create a sort of meta language as well about how foreign investment should occur, how should the relationship between states and foreign investors be managed, which I call a legal imagination. And my claim in the book is that investment treaty law today is remarkably similar to that legal imagination created in the 1950s and 1960s. So that meta language, that vocabulary remains very, very relevant. It's not just the institutions, but also that language that remains very relevant. And this legal imagination is also very relevant when it comes to investor obligations, or to be precise, to the lack of hard law international corporate obligations. Looking at the significant work of business actors at crucial moments in history, such as the discussions at this creation of the International Trade Organization and the Havana Charter in the late 1940s, we see that international business was very interested and played a crucial role resisting the creation of international corporate obligations. And that perhaps they pay more attention to the resisting these obligations than to the definition of strong rights and ISDS. So what we see, for instance, is that while all firms were very strong advocates of international protection and investor-state dispute settlement, most firms, the International Chamber of Commerce was very strong about this, didn't want obligations. And the obligations that were established in the ITO Charter that was never finally ratified by the international community included the obligation for corporations not to interfere in domestic politics, to respect domestic law, and to adapt to domestic development plans. And so what we see is that at other key moments in history, 1970s, 1990s, 2000s, the different business organizations, the ICC particularly, continue to work hard to prevent the creation of international corporate obligations. And they offer instead voluntary standards, guidelines. So my thesis in the paper is that the legal imagination that dominates international laws on foreign investment, both investment treaty law and business and human rights, is closely linked to this politics of decoupling rights and obligations. And that we should see the history of this field of the laws of foreign investment altogether, both rights and obligations, as a history of the diffusion of investor rights as much as the resistance of investor obligations. This view is different from dominant accounts, I think, because I place financiers and business associations at the origin of this legal imagination as consistent guardians of these imaginations. So, of course, we know that Global North states have supported this position and they have resisted, for instance, hard law corporate obligations. But what my research shows is that business actors first imagined this way of handling foreign investor relations, and they put forward this position even at times when Global North countries were reluctant or resisted this view. Now, what is important for a Global South perspective is that pushing for this position was never that easy for business actors and the Global North more in general, particularly because the Global South had a strong intuition that foreign investors were key for the international economy. And at least since the 1950s, you can see that. What is interesting is that Global North, Global South, and business actors all have an agreement that the international economic system was characterized by the lack of certainty. What seems to be constant, noted Kenneth Hill from the Jamaican embassy in Washington in 1975, is a recognition of the need for reasonably well-defined rules of the game. So the different actors agree that there is indeterminacy. And what this implied in the post-World War II in the 1970s and perhaps today is that the field of international economic law remains in flux. There is indeterminacy. There are always new challenges coming up, new policy issues. And in a way, we, the different actors, not just the Global South, but also the Global North and business, we are all experiencing different levels of indeterminacy. So I think in this context, looking at the work, at all the practices of business actors can help us can help the Global South, if you want to learn a more effective way of participating in the definition of the rules, participating in the creation of the rules. My take from the work of business actors is that ideas are not enough. That is not a question of getting the right ideas. I don't think there is no reason to assume that the ideas of the business coalitions of the International Chamber of Commerce are better ideas than the ones put forward by the Global South. Thank you, Tracy. I think what is fundamental here is practice as well, that we should be looking at how they do things. So I found in the paper that business wasn't always very well organized, but eventually they managed to organize and act closely together, networking, creating think tanks, insisting about certain ideas when the global North countries in particular were reluctant. And in particular, they invested a lot of work and effort in creating a grammar, a vocabulary, in imposing, if you want to, a way in which we should be talking about certain things. I mean, Latin America and the Caribbean, I was talking about the intervention of Kenneth Hill, have a long history participating in the creation of international economic law during the ITO Charter, the Charter of Economic Rights and Duties of States. Ecuador was a key promoter of the legally binding instrument that is being negotiated. But upon reflection, I have the intuition that Latin America, the Caribbean, and the Global South more in general, we have kind of lacked this ability to create a strong practice, to network enough, to create think tanks, and to insist about questions that perhaps face a little bit of resistance today. So, of course, we should be looking about having the best possible ideas, but I think also it's a question of thinking about the practice. And in this regard, I think academics will have a very important task, because we can contribute to creating a practice, a quote-unquote practice, a way of engaging a discussion that is a necessary condition for rethinking certain rules and rethinking a different legal imagination. So just to conclude, among others, I think we academics, we can teach the international law on foreign investment as if international treaty law, ISDS, and business and human rights were exactly the same field. We can resist the politics of decoupling in our teaching or in our writing as a way to try to rupture this language and vocabulary that has become prevalent. Thank you very much.
Thank you so much, Nicholas. I'll hand over to you, Fabio.
Many thanks, Tracy. Greetings, everyone from São Paulo, Brazil. I'm super happy to be part of this panel, and I really want to thank the invitation, Nico, Tracy, Chantal, also my fellow panelists. It's great to be with you and to have this opportunity for a conversation. I find this talk, this panel, super strategic. I must recognize my own limitations in terms of dealing with South Americans, very restricted, in a way, practice of dialogue. So I'm really happy to have this opportunity to broaden my conversations and to exchange ideas with you all. So reading Nico's paper, who's also an old friend, and we have been discussing these things, it was, Nico, really, really enriching. And I cannot agree more with how you ended your comments today about the possibilities for academics, for people who study international law, to kind of open space for this different legal imagination. So this is a bit what I wanted to comment on, because you have this strong historical take in the paper, and I think this is the most productive way to use history in international law today, precisely to open space for political imagination in our heads, and looking at the past, connecting the past and the present, and the way that you are doing in the paper does open that space. So I just wanted to maybe put our attention in something that you mentioned throughout your article, Nico, about Latin Americans again were resisting. This was resisted by Latin Americans, and then this is of course it's very good to read, and I want to just to kind of emphasize this, that okay, we've been somehow trying to shed light on the problems of this imagination of the world, of this, especially when with foreign investment, with having this focus on investor rights and leaving the obligations under the rug, just and then keep on trying to shed light on the issues of having such a unbalanced scheme when we deal with foreign investment. So it makes, and this is what I wanted to make kind of shed light, it does make a difference on who's telling this story, right? So it does make a difference that we are here, people from Latin America and the Caribbean, trying to have a conversation together. So the issue of positionality to me is really strong, and I think it has to be somehow be expressly out there in a way that I don't think international law is the same everywhere in the world. It's actually different. It's experienced differently in different places across time and space. So it does make a difference in actually seeing who's telling this story. No? So in this setting, when you say that we need to actually go deeper into this politics of decoupling, putting together this idea of rights and obligations, and actually this open space for going deeper into the history of those who actually tried to resist, even if with limitations, problems with their political projects, with their political alliances. We might not be talking about super revolutionary Latin Americans that were resisting these schemes in different moments in history, but at least there was some alternative perspective or some alternative understanding of how these relations between host state and investors, how they should be organized, and somehow how the role of international law in this relation. So different takes on that. So this is a super long history, a story in Latin America, the story of resisting this interferences from other places, but also our such a persistent question of how we can leave this condition of colony behind, how we can modernize our region, and then how these questions have changed into development, into other projects for Latin Americans and Caribbeans, now how we can leave this condition of colony behind. So what I'm trying to say here is that we know, it seems to me, and it's so clear, I also work with the history of international law in Latin America, dealing with the issues of intervention, and we know so little of this alternative legal imaginations. To start with, people mainly, we have so many people doing research in English, so just changing the language and changing your archives, assessing new texts written in other languages, this can also diversify our look at the past, the way we engage with the past, to bring to the surface these different imaginations, more or less revolutionary. I mean, our past is not just a glorious resistance to this horrible investors or people who has interfered in the politics of our region. Of course, we have a past of the actual new colonial mindset just being put forward by our national elites. Now, this is something that you also mentioned in your paper, Nico. So I think we have here a wonderful possibility to actually open space for a different legal imagination, having our positionality very strongly put forward, that we are looking to these issues from the perspective of Latin American and the Caribbean. And just, I mean, I'm super excited with this possibility of going deeper into these different ways of thinking about world ordering and the role of international law in this project. I hope we can somehow bring back this creativity, this, as you said, no, Nico, this possibility of being more strategical in the way we think about our practice. And I'm not happy with the status quo. So that's why I'm saying that we might need some change.
Thank you so much, Fabia. And I want to turn over now to Kevin Davis. Kevin?
Thanks, Tracy. Well, it's a real privilege to be here, since although I'm a Caribbean national, I'm actually based in New York City, which is not just in the global north, but in the very center of the global north, probably as far from the periphery as you can possibly get. So I do feel quite grateful for being included. About the paper. So first of all, I completely agree with Fabia's comments about the historiographic possibilities that this kind of analysis opens up. So I won't go there. I'll focus more on the paper in front of us, I guess, and just some of the thoughts I had about some of the substantive aspects of it, as opposed to the methodological ones, I guess. So it's a really helpful paper, right? It traces the historical development of international investment law, which has been done, but the helpful part is the way it's organized around this tension between protection on the one hand, investor protection on the one hand, and investor responsibility on the other hand, right? And the contestation around that. And organizing the paper that way around that basic tension is really helpful because it's really about a fairly long series of quite complex instruments, and it allows the instruments to be lumped into, each of them to be lumped into one of two broad categories. But I tend to be a bit of a splitter rather than a lumper when it comes to my academic inclinations. So the core comments I'll have on the paper will focus on encouraging Nicholas to basically create more categories, to do more to differentiate some of the alternative approaches to creating investor obligations. And that's a project that goes beyond the paper, and maybe it's in the book, which I have not read, I have to confess. But here it goes. Actually, before I do that, let me just make one comment on the sort of big normative question here, right? The sort of political theory question that this is circling around, which is really, should foreign investors' legal status be superior to that of local actors, or equal to or inferior, right? And there's this part in the paper where he suggests that the basic dilemma is that these foreign investors are being treated as outsiders with rights superior to those of locals, and instead they should be treated as insiders. And I actually wasn't sure that that was so obvious, right? So the implication is that they should be treated as insiders and sort of with equal rights to local actors. That's what I took from that. But I think there's an argument that they should continue to be treated as outsiders with a status inferior to those of local actors. And I think there is a tradition of that. If you I think of the Calvo doctrine as being more in line with that perspective. So just a quick comment on the sort of, I thought the endorsement of this idea of treating foreign investors as insiders might have been a bit too quick. So that's just a comment on the normative sort of hint there, the hint of a normative argument. So I guess I was, as I said, I was looking maybe more for clearer specification and differentiation of the alternative. So I get the neoliberal decoupling, right? Investors have rights under international law, but no obligations. The obligations are assumed voluntarily, right? So that's very clearly set out in the back and forth about that. But then on the other side, the responsibility side, I think there are actually several different ways in which investor responsibility can play out, can be implemented. So one approach, which I'm going to suggest as sub-approaches within it, is international law imposing responsibility on investors. And I thought that could have been a section on its own, right? Because there are different ways in which investor responsibility can be administered and implemented, right? And some of them are more or less consistent with decoupling. So you can have investment tribunals implementing these obligations as counterclaims or defenses, as a bad faith kind of defense, or at the instance of the host state. So there's an interesting paper by Jackson Shaw Kern that came out recently suggesting, originally actually the idea was that host states could initiate investor state arbitration, and that's another possibility. Or you talk about the idea of having these in specialized tribunals. So now we're into decoupling, but it's not clear that that's a bad thing if those specialized tribunals have teeth. Or alternatively, in the courts of the home state, which is actually one of the options in that Morocco-Nigeria treaty that you cite. And so, I thought just breaking out those alternatives is going to be an interesting future project, because there are different ways, as I said, of imposing investor responsibility under international law. And I have to say, I'm not clear on why the argument is that we should resist decoupling, because the good thing about decoupling is that it takes the enforcement of these obligations out of the hands of investment tribunals who are not necessarily going to be sympathetic to these concepts, as you point out. So again, the normative argument wasn't entirely obvious to me. Let me just quickly say, I think there are a couple of other hints of models in there, in the article. One is this, there are some references to the role of trade unions, right? And so I was wondering if there's another approach, is what you might call something like the progressive neoliberalism. So still no obligations imposed by international law, just the voluntarily assumed ones. But if we can alter the bargaining power, right? If trade unions, for instance, are involved in the negotiations, it's not just host state to the firm, but to the investor, but also unions negotiating across borders and so forth, that could shift the bargaining power. It's still consistent with the neoliberal model, but there are different results, possibly. So that, I thought, might be worth carving out as an alternative path, this progressive neoliberalism. And then also, home state responsibility is another approach, right? So where it's not investor responsibility, but home states have responsibility for their investors. And that, I think it's worth breaking that out as well. So it could either be that some international tribunal enforces the obligations that are imposed on the home state. That's, I guess, what would have happened under the new international economic order. Or an international organization, as was contemplated in the Havana Charter. But again, that's a different approach. And the virtue of that, which the NIEO, I think, recognized, was that it recognizes the systemic or the potentially systemic and historical roots of exploitative foreign investment, as opposed to saying, oh, it's just that one company, right? Often these companies were backed by states. So again, breaking out the home state idea, I think, is important. And then finally, something that's not in the paper, but I think is actually an important feature of most recent developments, especially in the EU, is just domestic. Forget about international law, because I'm not actually an international lawyer, but just the fact that the home states might unilaterally regulate these firms and impose substantial obligations on them in the way that the EU is doing with supply chain responsibility. That's worth thinking about, right? I know it's going beyond international law, but if we're thinking about this broader phenomenon of investor responsibility, I think we'd have to take that into account. So I think I'll stop there. But again, that's not so much about the paper in front of us. These are really directions for moving forward. So thank you.
Thank you so much, Kevin. Thanks so much, Kevin. And I want to hand over to Chantal now.
Thank you, Tracy. Hi, everyone. And I'd like to thank Tracy and Nicholas for inviting the ILA Caribbean branch to collaborate with Mona Law and the School of Law at the Universidad de Valparaiso on this timely dialogue between Latin American and Caribbean scholars. And this dialogue is very much in line with the branch's commitment to bring together persons with an interest in promoting the development and understanding of international law in the region. Now, the dominant paradigm of international investment law is really focused on investor rights, and more specifically, states committing to provide protections to a broad array of investments and guaranteeing investors access to arbitration to claim damages for breaches of those protections. And investment protection focused treaties are not oriented towards sustainable and responsible investments for a number of reasons. Now, one reason which Nicholas's paper highlights is that these treaties don't really treat investors as stakeholders whose actions are critical to advancing sustainable and responsible investments. And so through their almost exclusive focus on investment protection, these agreements typically don't address investors' obligations or provide mechanisms for holding investors accountable. And so they are imbalanced as a result. What I wanted to touch on as a negotiator is how the legal imagination of many investment treaty negotiators is captured by this existing paradigm. There almost seems to be resignation to the absence of investor obligations in investment treaties. I've often spoken to negotiators who would mention that, they are open to the idea, but they almost expect before the start of negotiations that the idea would be shot down by their partners. And even where provisions on corporate social responsibility or responsible business conduct are included in investment treaties, interestingly, they're cast within the context of state obligations, because it's assumed that these treaties can't place obligations on investors. The investors aren't parties to the treaty. So typically what agreements that touch on CSR or RBC will do is states will be required to encourage investors to adopt these types of standards. And what's striking is that in even recent negotiations, some states have maintained that it's inappropriate to even place these types of obligations on states, because that would require the states to take actions to influence what are essentially boardroom decisions. And so most attempts to reform investment treaties haven't really fundamentally upset this predominant focus on investment protection. And therefore, they may not adequately channel investment towards sustainable development. And as Nicholas has pointed out, very few of the newer generation investment treaties place obligations directly on investors. And that's why I think it's so important to unpack why this paradigm exists and how it actually emerged. And I think Nicholas's body of research on the politics of decoupling foreign investor rights and obligations is extremely valuable. I wanted to touch on what I think is important to integrating investor rights and investor obligations into international investment law. I think it requires, I'm going to touch on two elements that I think are required. I think it requires continued dialogue on investment treaty reform at multiple levels, the national level, bilaterally, regionally, multilaterally. And I think that dialogue has to involve both governmental and non-governmental actors. And that's why a forum like this, where the academic community is focusing on this issue, is also critical. And I think it involves the crafting of specific proposals. And there are important developments underway promoting a reimagination of investment law. And I agree with Nicholas that the recent report on human rights compatible international investment agreements is a useful step towards bringing both investor rights and obligations within the same field of international law. Now, in a reimagined international law on foreign investment, I agree that obligations on investors should be seen as an integral feature of sustainable development-oriented treaties. More balanced treaties would feature mechanisms for holding both states and investors accountable. And the Global South can contribute, or I should say continue to contribute to making this reform agenda a reality through state practice, through model investment treaties, through investment treaties that are concluded in the future, and importantly, tackling the elephant in the room, which is the reform of the thousands of investment treaties on the table, which are very much wedded to the existing paradigm. And in this regard, I wanted to touch from a Caribbean perspective on an attempt that was made now 10 years ago to actually, at least from the region's perspective, fashion, what investment treaty obligations going forward for the region could look like. So back in 2012, CARICOM had drafted a template for what its investment chapters in its external trade agreements could look like moving forward. And that chapter imposes directly on investors obligations to comply with certain standards, acting in accordance with core labor standards, not circumventing international environmental or labor obligations, not bribing public officials, having in place local community liaison processes, for instance. I must admit that the template, I think, doesn't go far enough with respect to accountability. And so it only provides for the filing of counterclaims by host states. And I agree with Kevin that there are a range of other options that are on the table for holding investors accountable. As he mentioned, initiating cases against investors in instances of non-compliance with these obligations. But there are other accountability mechanisms that have been explored. Contact points are ombudsmen, joint institutions, fact-finding mechanisms, mediation and compliance functions, and even allowing for affected third parties like local communities to lodge and investigate complaints. Now, I touched on, and I just want to reiterate the importance of turning to the equally important issue of reform of existing investment treaties, which are largely focused on investor rights. There have been discussions about what possible reform options could look like, ranging from terminating these treaties to renegotiating them. I just want to end by highlighting this point, which is that a systemic reform approach needs to go beyond just adding on provisions that might address investor responsibilities to conventional investment protection agreements. In my view, that's not enough. Treaties would need to be completely reoriented towards sustainable and responsible investment, both with respect to their scope and the substantive rules that they cover. And I do believe that conversations like the ones that we are having right now can make a valuable contribution towards that reimagination of international investment law, so that we can move to a place where there isn't this resignation that what exists has to be the only model that can exist going forward. Thank you.
Thank you so much, Chantal. We're going to turn over to Umberto, and so we're going to be listening to a message from him in response to Nicolas's ideas and thoughts. So let's listen to Umberto, who recorded from Oxford University.
Hello, everyone. Good afternoon or good morning, depending on where you are participating in from. My name is Humberto Cantu Rivera. I'm a professor at the University of Monterrey, and it's a pleasure for me to join you in this very interesting event by the Caribbean branch of the International Law Association to discuss Nicolas Perrone's very interesting paper forthcoming in the Business and Human Rights Journal special issue on Latin America on bridging the gap between foreign investor rights and obligations towards reimagining the international law on foreign investment. This very interesting paper captures not just the evolution of foreign investment and how it has created inherent tensions with the field of human rights and specifically with international environmental law, but also it captures the way that the global South and specifically Latin America have positioned itself. And the Caribbean, of course, have positioned itself in relation to this very important topic. As we all know, foreign investments in many cases are beneficial, at least to some extent, to enhance the quality of life, to promote employment, promote education, promote higher standards of work, work-related standards. But at the end of the day, in many of those cases, these type of investments also tend to have a negative impact on both human rights and the environment, which faces then a very important difficulty, that of obtaining remedies. That element that has been very widely discussed in international investment law is at odds to some extent with international human rights law. And in my view, no document captures that specific limitation better, that contradiction better than the United Nations Guiding Principles on Business and Human Rights. As you're all aware, the UNGPs address the topic of the capacity of the state to actually adequately regulate foreign investors in its first pillar that addresses the state duty to protect. And in this specific case, one of the key elements there is to ensure that the state maintains a capacity to actually regulate the conduct of foreign investors. And that, in my view, has some very important implications. In the first place, it highlights how we're not talking about a separate, different role of the state. We're talking about the duty to ensure human rights and to respect human rights that is, of course, present, and not just in the American Convention on Human Rights, but also in the International Covenant on Civil and Political Rights. And that highlights how even in treaty negotiations of an economic nature, including investment and trade agreements, the state has a duty to ensure that its actions contribute to the respect of human rights. That's a key element that is there, and that the UN Guiding Principles try to frame in some level as part of the obligation to protect. A second point that is related to this is how important it is, as the Committee on Economic, Social, and Cultural Rights has elaborated, how important it is for states to actually be able to investigate, sanction, and redress any wrongdoing committed by investors. And in this regard, I believe the UN Working Group, for example, in its latest one of its latest reports on investment and human rights, highlights that contradiction and that tension. It is in the capacity of states to undertake negotiations that actually allow people to not be harmed by the actions of foreign investors. It highlights how, at the end of the day, it is the role of the state to ensure that those provisions that fall into the different investment agreements can do something, not just to focus on the investor and its own rights, but actually to focus also on some level of obligation, sometimes framed as part of the state duty to protect. In other cases, as the UN Working Group report suggests, focusing on a different perspective in that regard. So in addition to the logic of the UNGPs on how the state has a duty to protect human rights, that actually links very closely to the duty to ensure human rights that is present in international conventions on the field. One of the key elements that are currently under negotiation is actually the focus of what a UN treaty on business and human rights could do in this regard. I would like to speak from a personal perspective and experience on this, particularly because I've been very heavily involved in the negotiations as part of the Mexican delegation. But one of the key tensions that the treaty identifies is this discussion that was already present during the International Law Commission's report on the fragmentation of international law. And in that specific context, well, of course, as you all know, the ILC highlighted how we live in a context of international law that is fragmented by nature. And in that regard, the proposal to have a treaty on business and human rights basically focuses on one solution that addresses systemic integration. And that is recognizing that at the end of the day, when we speak about the link between investment and human rights, both realms actually create their own separate universes of obligations for states that are simultaneous and that have to be complied with in full simultaneously. So the proposal by the chairperson rapporteur of the Intergovernmental Working Group on the elaboration of a treaty actually relates to specifically that point, how to ensure that whenever a treaty is being negotiated, states will take measures to actually include provisions that facilitate human rights protection and environmental protection in the context of foreign investors' activities. So that's one point. The second one being a separate logic, which is that whenever there are treaties that are already in existence that may bring this, let's say, collision of interests, the logic will be of trying to find a way to interpret that specific provision or that specific conflict between the two treaties and between human rights and investors' rights in a way that allows for the mutual prevalence of both obligations to the extent possible, of course. So in conclusion, what I would like to highlight is how important it is for a region such as Latin America and the Caribbean particularly to actually discuss many of these issues, to highlight how policies can be an actual vehicle to ensure that investment contributes to the realization of human rights and doesn't focus on what has been the more traditional experience, I would say, in Latin America and the Caribbean, which is contributing to harm instead of contributing to the realization of human rights. Just a quick epilogue to share with you that the ILA is working as part of its 150th anniversary celebration that will take place next year in Paris, working currently on a series of white papers that will address, several topics related to international law, not just as we look at it right now, but actually how we should look at it with the aim of 2050. So how is international law going to be in 25, 27 more years? And as part of that, I would like to just let you know that one of the work streams that we are currently having in that space is that of business and human rights. A colleague of mine, Catherine Pedamon from Westminster University, and myself are writing a white paper on business and human rights. If you have any thoughts, any reflections that you think would be useful to consider as we do that, please feel free to share them with us. And we will do our best to try to include those perspectives and those ideas coming from the global south and particularly from the Caribbean into this very interesting work that we will have the honor of publishing next year. So thank you very much, and I look forward to engage discussions, continue discussions and engagements with all of you.
Thanks so much to Umberto. And we are going to end the formal bit before we open the floor and the discussion period to Jason Haynes.
Thank you very much, Tracy. Good afternoon, colleagues. It is my absolute pleasure to be here this evening and to have heard such wonderful comments shared by all of you. First of all, just to say, wonderful paper from Nicholas. I particularly like your diachronic assessment, the fact that you looked at this decoupling and the politics of it from a historical perspective, and it counted from 1946 onward to 2011, that there have been several references to developments that have taken place during that period, and of course, the policy associated with those developments. I want to focus a little on one of the important themes that I thought that came out quite nicely in your paper, that of the privileging of the global over the local. And in particular, I saw a couple of references to that throughout the paper, particularly when you spoke in relation to local communities and how historically they've been disenfranchised insofar as the protection of their human rights is concerned at the international level, through, of course, the international system of arbitration, but also more recently, the CSR regime, which I like, of course, that you described it as simply a placard to pacify the critique of environmental and sort of social activists. So I thought that was a really interesting comment. But from a Caribbean perspective, I found it particularly apt, your paper, because I saw, of course, some continuities between historic slavery and the processes related to how multilateral corporations in the slavery and slave trade context exploited the international regime at the time, and where rights did not matter. Rights mattered, rights of corporations in particular, but obligations really did matter from the perspective of these multilateral corporations. And of course, we have seen that continue today. So there are some continuities in that respect. One of the key themes that I particularly enjoyed reading about is the exceptionality of key actors insofar as they approached to the protection of investors on the one hand and the obligations of investors on the other. The fact that, of course, there's complicity traditionally between the UN, the OECD, the ITO, and indeed business actors is something that was particularly striking coming out of your paper. And that complicity, interestingly, and I think in the last few pages of your paper, relates in some ways to what we've seen recently in terms of racialized violence against local communities. And if any of you have had the opportunity to read, for example, the Copper Mesa and Ecuador case, you'd see very aptly how investors, through their exceptionalist tendencies and the support of their home states, as well as various business institutions, have committed actual acts of violence against communities by, for example, hiring persons to commit the firing on members of racialized communities, namely indigenous communities. One of the other areas that I found particularly interesting in your paper is the privatization of public harms, the fact that through this decoupling regime, our central focus, even when tribunals rule against investors, has been on that of contract rights and property rights. They have not recognized human dignity as a core aspect of their jurisdiction. And in that respect, therefore, the asymmetry of international investment laws, you've described it, continues unabated. Now, one of the fascinating themes that I've picked up on recently through arbitral awards in particular is that dichotomy between how quickly arbitral tribunals in particular and the international community, more generally speaking, reacts to circumstances in which states take measures to respond to certain activities of investors that they perhaps don't particularly like, but which have the effect of undermining investors' rights. Take, for example, the Von Pezold and Zimbabwe case, in which the sort of reacquisition of lands from the white communities in Zimbabwe was met with sanctimonious condemnation by arbitral tribunals as well, more generally speaking, of the international community. So they were very quick in their response to those so-called human rights violations in that respect. But when it comes to violations against local communities, for example, in Ecuador, in Bolivia, in Chile, we haven't seen that enthusiasm that we've seen in other contexts. Now, like Kevin had mentioned, as well as Chantal, I believe, going forward, I'd really like to for us to focus a bit more on the responsibility of home states. And of course, there's recent jurisprudence out of Canada, a case involving a company that committed modern slavery that would be very instructive, I think, in informing how, if the international community has not been able to respond through its efforts to decouple, to deal with decoupling, and how perhaps home states can in fact take some role in that respect. But of course, counterclaims as well, amicus curiae, and indeed specialized tribunals, I think, would be really useful in rebalancing the obvious asymmetries that we've seen and which continue to adversely affect, as you've mentioned in your paper, local communities. So thank you very much, and I look forward to engaging further in a bit from now.
Thank you so much, Jason, and thank all of the panel for the comments and observations. But I wanted to also just note the way in which Fabia took up this question of the value of a new legal imagination, and the way in which different panelists also engaged with Nicholas's idea around decoupling. Kevin suggesting that there may be value with some separations, also some conversation around different spheres, global and local, but an interest in the ways in which the differences in fields and areas have come to have really material significance for how business is conducted throughout our regions. A lot of discussions from, I think, every person on the panel around what new practices could look like. New practices are really also about how we imagine and how we think and how we connect with each other. But new practices also included new ways of resolving disputes, new methodologies, new treaties, new ways of thinking through resolving the kind of difficulties which were being described. We heard Umberto around this, we heard Chantal around this, we heard Jason around this, we heard Kevin also around this. And I wanted to first, in opening the floor, to turn to Nicholas, who may have some reflections on the observations of his friends and colleagues. Nicholas?
Thank you, Tracy, and I will be very brief. I think all the comments are very important, and as Kevin mentioned, in a way, they're also a bit of they're also starting points for continuing the project, for new projects, for collaborations. Just want to say what Chantal said really struck me as very relevant. You know that Morocco and Nigeria signed a treaty, that's Morocco's draft, with investor obligations. And then when Morocco tried to negotiate something similar with Japan, that was not possible. And that called, you know, when you talk to negotiators, and I have done that with many Latin American ones, I get the same feeling she got. I mean, that there is a level of resignation that they may have ideas, but those ideas cannot fly. And perhaps what I when I was insisting about practice and not the ideas, is that we need to create some conditions of possibility for those ideas, you know, to be able to catch. And in a way, the paper was kind of hinting in that direction. So the historical approach is a way of showing how for some actors it really worked, you know, to create that conditions of possibility. So I mean, I take Kevin's points, I think, are very important. But I also believe that it's, you know, how you deal with this experience of indeterminacy, and in this particular case, in the area of international investment. And if we think of international investment on this area as the one that regulates foreign investment, you know, as a complex, you know, transaction that requires rights and obligations, that we really need to get how we're going to do it first, and then we do the analytics, and then we see all the different opportunities we have. Because what we see otherwise is that, as Chantal was saying, at CARICOM, there was a very excellent work. They tried to get all the different options, but that doesn't fly. So how we together having conversations, you know, build up that situation where those options can be taken seriously, because otherwise it ends up being an academic conversation about ideas. And what we see in this area, at least, this is my intuition or my impression, is that when there are proposals coming from, let's say, the European Union or the United States, they are taken seriously, but they're not taken seriously when they're coming from the Global South. Although, as Jason was saying, is local communities in the Caribbean or in the Latin America, the ones that are more hurt. So there is an issue here. No, there is something that I think kind of, you know, calls for our attention. So that was on my main remark. And thanks for all the comments. I took notes of all of them, and they're gonna help me, you know, as I continue developing my work and my research. Thank you very much.
Thank you so much, Nicholas. Let me go back to the panel. Each of you may have some responses or reactions to what others said. You had very few minutes to offer some early thoughts. Please feel free to just unmute and offer your thoughts. I see you nodding your head, Chantal.
I just wanted to come back in briefly with respect to what Nicholas just said, because I think that issue he touched on about moving from an idea, which seems quite acceptable in principle, to a result that actually concretizes that idea is such an important strand that we have to work through. As I said, in my field of negotiating treaties, it's an interesting endeavor, but I firmly believe that we're at a moment where there are many currents moving in the direction of reform. And that's why I mentioned this conversation being so timely. That's why I mentioned the work that was recently submitted on, last year, on human rights compatible treaties, because it was striking to me to see this report, which would have been the culmination of rounds of consultations with stakeholders across the world, that concluded quite clearly that we needed to refashion investment treaties to, amongst other things, I'm not getting into all the elements, but amongst other things, clearly place responsibilities or obligations on investors. And it will be interesting to see how a report tabled by the UN actually, you know, is infused in state practice. I'm very much driven by what state practice is reflecting. And I agree with Nicholas that, you know, you often don't necessarily see a correlation between model treaty text and concluded provisions, or the kind of consistency in approach that will actually influence state practice overall. But I do think that we're at an important point that should be taken advantage of in terms of how the imagination of international investment law is evolving. It's not something that we should lose sight of.
Anyone else wants to jump in at this stage? If Fabio?
Just quickly, I just wanted to maybe make it clearer. I do believe in the power of historical narratives like the one we have in front of us, maybe not just to pick up solutions from the past. I'm sure, Nico, this wasn't what you were doing, no, but actually just to give oxygen for us to rethink the present. So I was really interested in reading the works you cited along the piece, Eduardo Novoa Monreal, Castañeda Neves, people that from Latin America that actually took their time to engage with the UN, or in the case of Novoa Monreal, it was a different story related to Chile and the nationalization and everything. But people that actually engaged with the vocabulary of international law, aiming to achieve change in the world. So it seems to me that once we start getting closer to these stories, going deeper in these materials, going deeper in these archives, which are not always written in English, and the stuff is not always in English, we can have this oxygen to actually rethink the present. So how can we engage with international law today in order to achieve stuff? And I mean, I'm not this hands-on person on investment law, but much more the one who's interested in different stories to diversify a little bit our repertoire now for thinking about possibilities. And this is something that your text, I was taking, like highlighting all this footnotes, because this is, where is our creativity gone? I don't know. I get angry at a few passages. What's happening to us? Where is this Latino Caribbean thing? Is it completely lost in a kind of past, glorious past or whatever? So this is something that, we should get back to this. And it gave me a lot of energy to read your piece and to go deeper, like to search more for stories like the ones you were telling us. I mean, I'm not a reformer, but I'm interested in this energy from the past. So thank you.
Thanks so much, Fabio. I want to take Jay's question. Jay, just tell us who you are first.
My name is Jay Butler. I teach at the University of Virginia. I teach international law, international business transactions, and corporate social responsibility. Kevin sent me the invitation yesterday, so I really appreciate it. And I enjoyed the conversation, even though I've not yet had a chance to look at the paper. I'll look forward to reading it when it comes out. I was curious, Nicholas, about whether you see any differentiation in the role of international institutions in terms of the constitution of the international legal imagination. So various large economies, Brazil and others, are not a part of ICSID, right? Are not members of ICSID. So I'm curious whether you see a differentiation in terms of that sort of international legal imagination depending on the participation in institutions, and if not, sort of where is the imagination being constituted, who's driving it along? Were questions that I imagine that you touch upon in the paper, but I'm also curious, perhaps to hear your thoughts.
Thanks. Nicholas, do you want to start? Others may wish to pick up on the question as well.
Sure. Yes. First, thanks, Jay, for the question. Yeah, that's to me, it's a central question. How does it start? What's the starting point? And I think when it comes to current international investment law, let's say investment treaties, ISDS, and the lack of obligations in those treaties, to me, it starts with business coalitions. It starts particularly with the International Chamber of Commerce. So when the International Trade Organization Charter, the Havana Charter, was negotiated just after the Second World War, that charter contained obligations for corporations. And that charter was negotiated by the Global North and the Global South. That was the final draft charter that was put for different countries to ratify. As we know, the United States did not, and then the whole thing collapsed. And the reason why the US did not do that was because the ICC, the US branch of the ICC, the US Council of the International Chamber of Commerce, was very strongly against it. And when you read the reasons, they say, well, actually protection is not very strong, but nevertheless, their big issue here are obligations. Obligations are stated in a very vague way, and that means that they could be interpreted in such a fashion as they could be expanded. As today, standards like fair and equitable treaty have been expanded. So that same story is repeated in different times. What the ICC provided, for instance, John Blair was a key person here. He was working for the ICC, and he was a legal advisor of Shell. Is the idea we're not gonna give hard law obligations, but we're gonna give guidelines. Then you have the 1972 ICC guidelines that were provided, and then the ICC and other companies like Shell, back then was Exxon, when the UN was discussing the possibility of having, a code of conduct, they gave a testimony saying that they were fine with guidelines, but they were not going to accept hard obligations. That you have the OECD discussions as well, that in a way were initiated as to kind of counterbalance what was happening in the UN. So fast forward 1990s, 2000, you see a similar thing. The first actors that come very strongly against obligations are the ICC and firms like Shell, or natural resource companies are always take a very strong position, both against strong obligations and also in favor of rights. And that coincides with what we see in Latin America and in the Caribbean. The firms that normally are, involved in this sector are the ones that are being accused, as is the case of Copper Mesa and Ecuador that Jason was talking about. So for me, and this is the argument I made in my book and in this paper, business coalitions are at the origin of this imagination, and then they manage to convince the global north. But we need to be careful when we kind of lump together, and this goes back to what Kevin was saying, not the global north and let's say the US or the European Union or European countries were not always in favor of this. It's not that every single time they were in favor. Sometimes they were reluctant or they resisted. And then you see firms insisting, and doing this kind of, networking and discussing and trying to organize, that I think is very important, how to create a practice that allows that, then that options that are resisted become then the normal. So that's very, very short answer to your great question. Thank you.
Wendy?
Thank you, Ms. Robinson. And good afternoon, everyone. My question is, because I had the opportunity to do an out-of-faculty course in gender and development at UA Mona, and it was very fascinating and interesting. My question is about how, like many organizations, I work for an international one, but we operate in silos. So we have investment treaties where we, dictate or we specify certain, terms, but, they do not coincide with other treaties that states will, sign to, such as like Millennium Development Goals, Sustainable Development Goals. And so my question is about reconciling the investment treaties with development goal treaties, because as had mentioned by Jason, I think it was, many times the marginalized get left behind. Their rights, are, pounced upon. They're taken for granted. I mean, the pays that they receive, for instance, from these international companies when they come to quote unquote invest in the countries, really does not, help with overall development of the entire country where we see foreign investment. So I wanted to just ask about that in terms of, how the silos can come together and we can work to, literally create sustainable development.
Thanks so much, Wendy. Jason, could you think about how you might respond to Wendy, and then I'll come back to others on the panel who may want to intervene. No, I see Chantal, I see Kevin.
A really useful question, Wendy. Thank you for asking. So your question about the difficulties associated with reconciling investment treaties on the one hand and human rights treaties on the other plays out as a matter of practice in many arbitral awards. And in fact, a couple of them that have been decided upon recently, I can think of Bear Creek Mining, for example. Arbitrary tribunals have said outrightly that they're not in human rights courts. They're not concerned with giving effect to human rights standards, and that they're principally concerned with this notion of, as Nicholas has been saying throughout, investment protection. So I think it's difficult in that context then to give primacy to the rights of persons like marginalized communities when it is that tribunals are hostile toward continents in human rights obligations that are provided for in international human rights instruments. But the scholars in the field seem to suggest that one way of getting around that is looking at the whole corpus of international law. Now, the applicable law in most arbitral awards would be international law, and international law invariably covers not only treaty law, but also principles of customary international law, which might encapsulate, for example, various provisions that deal with human rights matters. So the suggestion then is tribunals have an interpretive role to play in that respect, by looking at the whole corpus of international law and not simply just investment treaties. Of course, counsel for investors, the business community more generally speaking, and the majority of arbitral tribunals seem to reject that approach, generally speaking. What I have seen, though, is the dissenting opinions of a growing number of arbitrators arguing in favor of the same position that you've articulated. And in particular, I've seen awards, at least dissenting awards, written by Philip Sands, a renowned environmental specialist, who's argued in favor of such an approach. In terms of how do we mobilize, I know that certainly in Latin America, but less so in the Caribbean, persons have mobilized through the submission of amicus curiae briefs to arbitral tribunals. However, they've not been countenanced in all cases. In fact, in the vast majority of cases, tribunals seemingly reject these amicus submissions. And so outside of that, because of the limited role that individuals themselves, local communities have in the international investment regime, it means then that the voices of people on the ground who are affected by investment decisions and investors' decisions, they're not countenanced in most cases. But it doesn't stop, I think, us from mobilizing when indeed there are cases that raise human rights concerns to submit amicus, and hopefully tribunals interpret the requirements for admission of submissions in a liberal way such that the voices of the marginalized can be better accounted for.
Thank you so much, Jason. I'm going to take Pablo's comment or question and then go back to the panel for your thoughts and closing remarks as we wrap up. Pablo, and tell us who you are, Pablo.
Thank you very much, Tracy. My name is Pablo Agustin Escobar Villauri. I actually work for the Ministry of Foreign Affairs of Ecuador, and I'm directly involved into the renegotiation of BITs of Ecuador. So this dialogue is particularly useful for me. I think many very important points have been mentioned, and I just wanted to pick up one of them, and that is how can we impose obligations on investors? And that goes to the question as to how we balance the rights that BITs give or grant to investors with their lack of obligations. And that's a question that we at the Ministry of Foreign Affairs have been grappling with, because I think it was Chantal who mentioned that, of course, we can let our imagination fly and come up with all kind of ideas and proposals. But then when the negotiations come, it's very difficult to actually have an agreement with our counterparties, especially with some Europeans and I would say even with some Canadian friends. But now I think for the first time, I believe there is a positive scenario out there. And we have seen that some European countries have been putting in place or have been enacting some due diligence laws. France is one of them. And I believe to some extent there's some other similar discussion in some other countries. But I think an aspect that I found particularly useful or interesting was that recently the European Union, the Commission, I think, has put forward a proposal for due diligence, for which attempts to regulate the operation of multinationals, of European multinationals abroad. So I think that gives a positive scenario for actually incorporating those obligations into BITs. And I personally have been trying to see whether that would actually be possible to include those disciplines which which European countries possibly will have to abide for into the BITs, and therefore imposing or establishing obligations with regards to investors, at least in relation to due diligence, which I think is at least is one step forward. But I'd like to know what would the speakers think about this idea. That's something that we have been considering at the Ministry of Foreign Affairs. Thank you very much, Tracy.
Thank you. So in fact, I'm going to give anybody the chance to respond to that when they make their closing remarks. Pablo, thank you so much. And it's a real pleasure to have quite a few of you from ministries of foreign affairs. I see Jamaica, I see, and we had Ecuador. We also have attorney general's departments. I certainly saw Guyana. I saw Jamaica as well, and there may be others from Trinidad and Tobago. We had another state authority with us through Delreen. But it's just wonderful to have a range of actors who are in this conversation about what change in practice might look like. And many of you are in the middle of work in this area. So this has particular resonance. I'm going to start with Kevin and any of your thoughts as we wrap up, and to ask any of you as you make your concluding remarks to also respond to Pablo.
Thanks, Tracy. And I was actually thinking, as you caught me thinking about the conversation about the practical implications, right? And also this, and still going back to the potential value of decoupling, because since I'm not an international lawyer, much less an international investment lawyer, I don't automatically focus on that area of law and that set of instruments. And I worry that there's the sense that if an obligation is not in the treaty or in the arbitral jurisprudence, then it doesn't exist. But of course, that's not right. So there may be alternative legal instruments that are more effective in terms of imposing obligations on people, foreigners investing in the countries in the region. And here, I think it might be valuable to take a page out of the book of the business actors, right? They don't limit themselves to a single forum. There's a book called Global Regulation that Braithwaite and Draughus wrote probably a couple of decades ago now, where they documented that exhaustively, that the entire history of global business regulation involves firms and coalitions of firms strategically shifting the locus of reform from one forum to another. That's part of Nicolas's story, but that's a general phenomenon. So that, to me suggests, no, actually decoupling can be strategically attractive. And so building on that, sometimes we should also think about the fact that the most effective way to impose obligations on investors might depend on which investors we're talking about. So what works for US firms may not be the most effective for firms based in the EU, where I think all the due diligence and supply chain regulation is actually front of the mind for EU large firms doing business in the EU. And I don't think we have to worry about whether or not those obligations get incorporated into BITs. It might be most effective to simply just have a voice in the EU process, and which is actually a concern I have about that process, that it's not obvious that the interests of the South are being taken into account. And of course, finally, we have to think about what might be most effective for Chinese firms. It's interesting to have one of these. It's odd to have this whole conversation without, specific focus on China, but I'm not sure. Well, anyway, it might be a different kind of set of instruments if we're thinking about that set of investors, especially the state-owned ones or state-affiliated ones. So that was it, and thanks.
And I think, Kevin, in this process of reimagining the question of what non-investment lawyers and non-international lawyers may bring to the conversations, the ways in which they may see opportunities or avenues, and become part of the conversation as well, and thinking through new practices could be valuable as well. So I find it interesting too, because as someone whose main space is in international law, some of the other possible avenues immediately come to mind more easily. So very interesting interventions. Chantal?
Thanks, Tracy. I'm going to use the opportunity to just respond to a few comments that were made. Certainly can relate to what Pablo's intervention speaks to. And all I would say is, I think once, just two quick points. Certainly, of course, when negotiating, understanding what partners have been doing and how their positions have been evolving is extremely important. And it's useful to, of course, track the developments in partners like the EU. The Netherlands, for instance, their model BIT looks radically different than a Dutch BIT would have looked like years ago. But I just wanted to flag that I think the core issue that keeps coming up when discussions about investor obligations, however they're framed, comes up, is this question of accountability or enforceability. So that it's not just, you know, some kind of symbolic kind of statement about what their action should be, but this question of, should the treaties in some way include mechanisms for holding them accountable? And I think that's the question I think many negotiators often grapple with. On Kevin's point, I just wanted to reiterate that there are, of course, many governance of investment, of course, is grounded in various spheres of law, domestic law, contracts, treaties. So the treaties just form one part of the corpus of law that governs investment. And of course, obligations can be placed on investors in contractual settings, and they may be. There are domestic laws that may increasingly place certain obligations on investors as well. I think why Nicholas's research about the politics of decoupling is so important is it gets to this question of why has there been an assumption in the context of international investment law that obligations on investors frankly have no place. Because there are other fields of law, other spheres of law where non-state actors are subjects of international law, where they're not only the beneficiaries of rights, but you know, their responsibilities are also addressed. And I think it's very, I think because, as I said before, the imagination of so many actors in international investment law is captured by this assumption that you can't have in this sphere of law, in this field of law, obligations being placed on investors, but they can be the beneficiaries of significant rights and significant protections. It really is something I think worth continuing to think about. It is this project of reimagination is something I think that we should not abandon. My last point is in response to Wendy's comment. And essentially, sometimes it's very difficult, I find, or I should say it might be easy for arbitrators to arrive at certain conclusions because they're interpreting treaties that are obviously not oriented towards sustainable development outcomes. And so, you know, it's almost as if you're trying to extract a development outcome from a text which clearly was not fashioned to secure those outcomes. And that's why I think reimagining international investment law, starting from the viewpoint that if you are going to negotiate a treaty, it ought to be oriented towards sustainable and responsible investments, could very well lead to different outcomes in dispute settlement, because those interpreting the treaty would be interpreting an agreement which has made a far more concerted effort to take into account sustainable development oriented considerations. Thank you.
Thank you, Chantal. Jason, any last word before I go to Fabio?
Yes, just a point about capacity building, but in particular in ministries within the region. Certainly I can speak for the Caribbean region. I think that's something that really needs to be enhanced going forward. Very recently, I had to review a draft investment act for St. Vincent. It was sent to me at 11 o'clock to be reviewed by 12 p.m. an international consultant was asked to draft the act, and the act was lacking in everything that you would tend to see in a contemporary investment act that has a sustainable development focus, as Chantal has mentioned. And so I had to then insert those things that I thought were necessary in that context. And of course, there's a backlash with the consultant saying that, you know, it may not all go well for attracting foreign direct investment. So there's this false assumption that somehow that if indeed you have investor obligations, that somehow would detract away from attracting foreign investment. And that is not, of course, empirically proven, as the case is, maybe. So I think a lot has to be said then about the need for our stakeholders in the respective ministries that are responsible for negotiating these instruments to have the requisite skills and expertise to be able to negotiate and indeed draft text which, as Chantal has mentioned, are oriented towards sustainable development goals. Last year, we ran a project with Georgetown Law School in which we interrogated all of the bilateral investment treaties in the Caribbean that have been signed to date. And we then interviewed stakeholders in the respective ministries. And one thing became very evident is that most of them simply didn't have an awareness that their countries had signed on to these agreements and what the agreements provided for. And then more than that, they weren't particularly concerned about sustainable development issues and certainly not human rights issues. It didn't even, come into their contemplation. And so that's certainly something that we need to address going forward. And I very much hope that members of this panel can do some work in that respect, because I think it's important work.
Thank you, Jason. Fabio.
Okay, thank you all for this discussion. I just wanted to finish by mentioning that I was, Nico, pretty interested in the way you actually put human rights in the conversation with investment law. At least from my perspective, I wouldn't actually put all my heart and faith on the vocabulary of human rights to actually fix the stuff, as I'm sure you know from other conversations. But in any ways, I think your paper shows us how this has actually opened space for this conversation about investors' obligations to come up and to maybe take a different turn. And I was impressed by a few comments by colleagues here saying that there might be options to actually change stuff at the moment. So I'm not sure if this has to be with this coupling of these two subfields of international law. But in any ways, it's also not the first time that this happens. Just before your story started, so you're putting your timeline. You start with the Second World War and the whole reimagining of the economic order. But before, in Latin America and also in the Caribbean, we had this whole discussion about alien protection, no, Nico, and how there is this research about the Inter-American Court of Human Rights as a way to actually escape this arbitration and actually change this way of dealing with this issues related to investment, foreign investment in our region, and actually putting the human rights vocabulary in the story. So prior to this story that you're telling us. So I hope that this is also interesting, how we can see these different possibilities of the articulation of these different vocabularies in international law. And I think your paper is also showing us that human rights, at least to me, showing me, let me be express about that we can see different possibilities for this engagement with human rights. So this is something I also wanted to tell you. And many thanks for this conversation, and I hope we can continue our interactions here. Thank you.
Thank you so much, Fabio. Nicholas, the last word and helping us to wrap up and close the discussion.
Thank you, Tracy. I just wanted to add to the conversation that, as we know, the international community believes that foreign investment can contribute to sustainable development. If you look at the SDGs, that's very clear. If you look at very different UN documents, the idea that foreign private investment has a key role, I think it's shared. Then we need something, the international community needs something to make that happen. And giving rights is part of it, but I think that investors need to have also commitments and obligations, responsibilities. And once we get to that consensus, I think we are in a different world, in a world where it's how we do it. And then it goes back to what Kevin, Chantal, and Jason were saying, that different, there's like a toolkit, a menu, and different ways of addressing that. But yeah, I mean, I think that's the where we are here, and agree with Chantal that there are we are in a moment in which there is some kind of momentum crisis and rethinking that can open up the floor for doing that. And I thank you very much, all of you, for the discussion. And I think it was great to me, not just to talk about a paper, but also see how we have a common interest, where we are starting a dialogue and a conversation that hopefully might continue. We can discuss other papers. I think that the goal with Tracy was, we are so close and so far at the same time, and then we kind of have this opportunity now, thanks to technology, to reduce those distances and have a conversation and about these issues that are a common interest. And perhaps we can help our ministers and our ministries, as Jason was saying, to get better and to collaborate, exchange experiences, and and I hope that this is just a good start for a longer term relationship. Thanks to Tracy, to Kevin, Jason, Fabia, Chantal, Umberto as well, who couldn't be with us but record a message. I enjoyed this very much, and hope to see you soon again, if it's not in person, at least through the screen. Yes.
Thank you all very much. Much
Thank you.
appreciated. Thanks all. Good seeing you. Till next time. Tell us what you may want to talk about next time. Tell us who you want to be part of the conversations. Hopefully, this is the first of many of these kinds of conversations as we come to share company and community in multiple ways, and particularly talking about law across the entire hemisphere. Thanks, everyone.